and dreams are drawn in the cement. Our tale begins with two characters, Mr. Lim, the proud property owner, and Mr. Adam, the ever confident contractor. With handshakes and high hopes, they signed a contract, a promise forged in paper and protected by law. 6 months to build a shop hut. What could possibly go wrong?
Oi, boss. Oi. Contractor's here. Okay, please come in.
Hi.
Welcome. Please have a seat. Sorry, Mr. Adam, I'm engaging with your company for construction of my shop lot. As outlined in the contract, it has been stipulated about the details of our agreement, the purpose, consideration, price, and other requirements needed as outlined in the Contract Act. Also, in this contract, it has been stated how we're going to resolve any dispute that arises between both parties. Therefore, to be aware, Mr. Adam, the project must be completed within 6 months. In the event of the delay, liquidated damages of 5,000 ringgit per week will apply. Do you agree with these terms?
Yes, I do agree, but I would like some clarification regarding the liquidated damages clause. How will it be applied in this contract?
Liquidated damages are predetermined compensation for any delays in project completion. If the project is not completed within the stipulated 6-month period, you will be liable to pay 5,000 ringgit for each additional week until the completion. This ensures the accountability and adherence to the agreed timeline. Is that clear?
Okay, understood. I accept this term and commit to timely completion. Okay.
Additionally, Ms. Lina will act as the project manager on my behalf. She will be overseeing the construction progress and ensuring that all work is carried out according to the schedule and quality standards.
I appreciate that. I will ensure that my team provide regular updates.
But wait, as Mr. Adam flips through the pages of the contract, he stumbled upon terms that raise an eyebrow. Force major, liquidated damages, and the mysterious word of arbitration. What do they mean? Only time and perhaps a few lawyers will tell.
Mr. Lim, I would like to seek clarification regarding the term in the contract which state that a party will not be held liable in the event of force majeure, and the next term is that if dispute arise, party will solve the dispute through arbitration. Could you please explain this further?
Certainly, Ms. Ayam. The clause means that if either party fails to fulfill their contractual obligations due to circumstances beyond their control, such as the natural disaster, this failure will not be considered as breach of contract, and the affected party will not be held liable. For the dispute resolution clause, it means that we will go for arbitration, which means that whenever there's a dispute arise, both parties will resolve the dispute by appointing an independent person, which is stipulated in the terms, named Side Regional Council, to give a fair resolution. Do you have any concern, Ms. Adam?
I think I have no further concern about the contract, and I agree with all the terms concluded.
Okay, so
I have to sign here?
Yes, you do sign.
Okay.
Right, excellent. So I appreciate our cooperation with Ms. Ayam. Thank you. Alright.
2 months after the deadline, Mr. Lim returns, not to the burnout he imagined, but to half-built train, and he is not pleased. Delays, excuses, and heavy rain have soaked more than the soil. Yes, what do we trust? Tempers flare, accusations fly, and both men stand their ground. Mr. Lim demands what he's owed anti-contract, while Mr. Adam clings to a clause he hopes will save him. With no very good mother to cry clarity, they both do the next best thing, call the lawyers.
Wait, tell me what I did. No, it's not my fault. It's not my fault.
And so, our heroes, on opposite sides of the same agreement, seek wisdom from the sage of law. Mr. Lim turns to Miss Farah, sharp and fearless, to remind him of Section 40. When one breaks a promise, the other may seek justice. And under Section 75, he just might get it.
Mr. Lim, after reviewing the case fall under Section 40 of Contract Act 1950, which means when the contractor failed to complete the project on time, this constitutes a breach of contract, giving you the right to seek damages, even terminate the contract if necessary. Would the liquidated damages clause still apply? Yes, under Section 75 of the Contract Act 1950, you are entitled to claim 5,000 ringgit per week for the delay. However, Mr. Adam could argue that the penalty is excessive or unfair. Could he argue that the delay is beyond his control? Possibly, if Mr. Adam proved that the delay were due to force majeure, such as extreme weather, supply chain disruption, or labour shortage, he could challenge the liquidated damages clause, but the liquidated damages may be waived under a few circumstances. First, if the event is explicitly covered in the force majeure clause of the contract. Second, if the event directly causes the delay or default. Third, if the affected party has taken reasonable steps to mitigate the impact. Can you understand that? Yes. As you can refer to the case here of Syarikat Ching Trading, Sendirian Berhad, and Syarikat Perniagaan Kelapa Sawit, where the issue is whether a sudden government export ban was a force majeure. The court accepted the export ban as force majeure event, discharging the seller's obligation to supply goods. However, the burden proof is on him. But now, the contract is in your favour, which, in the existence of the contract, it has been explicitly stated that if any force majeure event occurs, the party will not be able to raise a defence of force majeure, as force majeure has been excluded from the contract.
Meanwhile, Mr. Adam sees Mr. Ross, his legal guardian in this film, who listens carefully and speaks of force majeure, impossibility, and hope, though even he admits the toll was not entirely unforeseen.
Hello, Mr. Rush. Can I come in?
Yes, you may come in.
Okay, Mr. Arish, I have received a legal notice from Mr. Lim. He is demanding RM 40,000 ringgit for the delay, but the delay wasn't entirely my fault. There was supply chain issue and extreme weather condition. What can we do about it?
Ustaz, please.
Sampaikan salam.
You might not be able to have a valid force majeure defense. Force majeure is not explicitly defined in Malaysian statutes, but it is governed by Contracts Act 1950 in Section 57, and it covers the possibility of performance due to unforeseen events. Next, it was also supported by Civil Law Act 1956 in Section 3. It allows the court to refer to English common law principles on frustration of contract. As we can refer to the case of Classic Maritime Inc. and the Women Bahaya, the court ruled that force majeure could exempt liability for liquidated damages if the event was truly beyond control. Both of these sections and acts emphasize that if you can prove that the delays were due to unforeseen events beyond your control, you may be able to reduce or avoid liability for liquidated damages. But this defense cannot be applied when during negotiations both parties have agreed to the terms of the contract which exclude force majeure from being used if an inevitable event occurs. Therefore, in this case, you, Mr. Adam, unfortunately cannot raise defense of force majeure here, as it is stated during the negotiations that force majeure cannot be used.
Oh, I see. Other than that, I'm concerned. Do I need to proceed with a legal lawsuit?
Not necessarily. I've reviewed the contract and it includes dispute resolution clause requiring disputes to be resolved through arbitration, which is governed by the Arbitration Act 2005.
Can I know how does arbitration work?
But here, where RTL takes a magical plane, because instead of sword fight and courtroom, the contract holds a special clause, arbitration, a secret passage to a peaceful ending, hidden in the fine print. The guidance from the AIAC rules and the Arbitration Act of 2005. The parties learn that not all conflict needs a courtroom. Sometimes a table and a neutral guide will do.
Arbitration is a private dispute resolution process where both parties agrees to have an independent arbitrator to hear the case and make a final decision. Section 9 of Arbitration Act 2005 enforces arbitration agreements, meaning you must resolve this matter through arbitration instead of going to the court. The dispute must be resolved through arbitration under the AIAC Arbitration Rules 2023. Under Rule 2, Clause 2, arbitration officially begins when the AIAC received the notice of arbitration and fees.
So, do we get to choose the arbitrator?
Yes, Section 13 of the Arbitration Act allows both parties to agree on a single arbitrator. If they opt for a three-member panel under Rule 3 and Schedule 1 of AIAC, each side selects one arbitrator and the two chosen arbitrators appoint a third to lead the process.
That sounds fair, but what if Mr. Lim tries to manipulate the arbitration process in his favor?
Arbitration is designed to be neutral. Under Section 20 of the Arbitration Act, parties can agree on procedural rules, language, and the location of arbitration, ensuring that neither side has an unfair advantage. Additionally, arbitration is confidential, meaning sensitive business will not become public.
That sounds better than a lengthy and costly court case. But is it the arbitrator decision final?
Yes, under Section 36, arbitrations awards are final and binding. Courts in Malaysia and many other countries enforce arbitration decisions under the New York Convention.
What if Mr. Lim refused arbitration?
That's an important point. Arbitration is only possible if both parties agree to it. However, there won't be an issue, since the contract contains a mandatory arbitration clause. And Section 10 of the Arbitration Act allows us to request a court order compelling Mr. Lim to proceed with arbitration. He cannot ignore the dispute resolution process.
So, that means Mr. Lim has no choice but to proceed with arbitration, right?
Exactly. Since both of you agree to this clause, when signing the contract, you are legally bound to follow this process.
Alright then, let's proceed.
And so, the day came. In a quiet room, away from hammers and hard hat, both sides presented their stories to the wise arbitrator, Daniel.
Good afternoon and assalamualaikum everyone. We are here to resolve the dispute between Mr. Lim, the client, and Mr. Adam, the contractor. To be precise, for you all knowledge, today's discussion will be confidential and not be published publicly outside this office. And also, at the end of this discussion, we need both parties to have a consensual consent to settle this issue down. So, today's meeting will be covered under Arbitration Act 2005 and follows Rule 3 and first schedule of AIAC. Also, we need to refer the original contract made by of you as our initiative to resolve this dispute. As we need to follow Mr. Lim, you are claiming RM 40,000 in liquidated damage for 12 at least. Right? Is that correct?
Yes, that's correct. According to the contract, any delay beyond 6 months incurs 5,000 ringgit per week in liquidated damages. Mr. Adam has not met the deadline, so has to pay.
With due respect, Mr. Arbitrator, the delays were caused by unforeseen circumstances beyond my client's control. There were major supply chain disruptions, labor shortages, and persistent heavy rain. We did everything possible to mitigate the delays.
So, Ms. Lina, as the project manager, can you confirm whether these delays were unavoidable?
Yes, Mr. Daniel, some delays were unavoidable due to material shortages and weather conditions. However, I believe better planning could have reduced certain delays.
Given the circumstances, my client is open to a fair resolution. We propose that Mr. Adam completes the project within 1 month, and instead of 40,000 ringgit, my client is willing to accept 25,000 in liquidated damages.
I think that is a reasonable compromise. My client, I think, is prepared to accept those terms and ensure completion within the agreed time frame.
Alright. Well. The final resolution is as follows. Mr. Adam shall pay RM 25,000 in liquidated damage, and the project must be completed within 1 month. Both parties agree to the settlement?
Yes, I agree.
Yes, I agree. Alright. Then the matter is settled. Thank you for cooperating to reach a fair resolution. Thank you.
The contract was breached, liquidated damages were due, and as for the force major claim, in the land of Malaysia, everyone's car is no variable. Heavy rain is no stranger.